Today I will be doing some patent law review. This is an overview, the first part of my patent law review course. If you like my channel, please subscribe. The main topics are 35 United States Code 101, which is all the things you can basically put a patent on. 35 US 102, which includes Pre-American Invents Act and Post-American Invents Act, which happened on March 16, 2013, which is basically an overview of prior art. 35 USC 103, which is obviousness to a person in the field. 37 CFR 112, which CFR stands for Code of Federal Regulations. This is basically the law about how the patent is actually written and the language that can and can't be used. And I will also be talking about additional key concepts. So some key dates to remember are 1. March 16, 2013, the American Invents Act. So new 102 is anything on that date and afterwards, and old law 102 is anything before that date. And again, 102 is prior art. December 8th, 1993, NAFTA, Mexico and Canada. So that date, NAFTA took effect. Just those two countries with the United States. January 1st, 1996, the WTO took place, which involves over 60 countries. Chapter 700 of the MPEP, which is part of the United States Patent and Trademark Office Code, which goes from Chapter 100 to Chapter 2900. Of those 2900 chapters, Chapter 2100, Chapter 700, and Chapter 600 are the three most important chapters, which cover altogether 70% of the material. Chapter 2000 is the most important. Chapter 700 is the second most important, and Chapter 600 is the final chapter. The other chapters make up the other 30% of the material to some extent. We will cover that in a later lecture. So Chapter 700 is primarily about all the reasons you do not get a patent. Not responding in time and running afoul of some law or procedure. Rejections. Rejections are based on law Title 35 and are appealable. And the way I try to remember this is re-appealable law. That's my mnemonic. Rules. Can be objected to and are petitionable. Prior art. This is 35 USC 102. In general, prior art is all about comparison of earlier dates. First to file, that's new law 102, which happens March 16, 2013, and onwards. First publication or swear by earlier invention could be referring to before March 16, 2013, and has everything we are claiming, which means someone else put a patent down on a light bulb, and you decided to make the exact same light bulb, no changes. So you can't put a patent on existing prior art. Additional note, an anticipation rejection can be a single rejection. Some challenges to anticipation rejections are bad date, filing date is earlier than prior art or pre-American Invents Act, or some exception to get behind prior art, or the examiner has misinterpreted the prior art, missed a feature, function, element, or step. A patent agent is one who passes the USPTO patent bar exam, and a patent examiner is the same except that they work at the DC office and they examine the patents that come in. Patent agent just is the one who files the patents, and a patent attorney is one who passes the patent agent bar exam and also passes the regular bar exam and has gone to law school in most states. 35 USC 102, all about the prior art. Some main points: challenge and anticipation rejection. Bad date or filing date is earlier than prior date, or pre-American Defense Act, some exception to set. Behind prior art, or the examiner has misinterpreted the prior art. Missed feature, function, element, or step. Prior art comes before patents. Disclosure comes before patents for exceptions. Okay. These next two slides, which conclude my lecture today, my mini lecture today, are the most important two, which try to get you used to the first two parts of 35 USC 102 prior art, which is where most of your problems are going to lie. Almost all the difficult questions on this exam will come from prior art 35 USC 102. Okay, 102A1, and it's important to notice that it's 35 USC 102A1 and etc., because sometimes questions won't refer to it as prior art, but rather refer to it as the particular number relating to the law. So you'll have to know these numbers exactly. So 102A1, you cannot file a patent on prior art. That sounds pretty reasonable, right? If someone has published a paper in Scientific American over a year ago describing your invention, then it probably wasn't your invention and you cannot file a patent on it, especially over a year ago. We're talking prior art here. Okay, so some exceptions and disclosures. 102B1A, disclosure by inventor within 1 year. So let's say about my invention 6 months ago, that's okay. I still have another 6 months to the day to tell the patent office that I wish to put a provisional patent on my thing. However, if I wait 6 months and 1 day, I've waited too long, and I can no longer file my provisional patent. 102B1B, disclosure by a third party from inventor within 1 year. So that's if I tell Bob, and Bob says something about it. Whereas 102B1A, I put a publication in Scientific American 6 months ago. I still have another 6 months to the day to file my patent, or my provisional, either or. Provisionals are a lot cheaper to file, so generally you file the provisional first, and it gets you into line for filing. Okay, so 35 USC 102A2. Okay, you cannot file a patent on something that someone already has a patent on. So let's say someone invented a light bulb 50 years ago. Can I file a patent on it? No, I cannot, because someone already has filed a patent on it. Yes, the patent has expired, but that doesn't matter. It's already known. It's more than a year. That's the important part. Has it been more than a year or less than a year? Okay, exceptions. 102B2A, disclosure and not yet published patent. So that means that someone else has filed a patent or a provisional, and it's not yet published, but it's known to the patent office. There is a way to search these things, because they are public knowledge once you disclose to the patent office. So it's not a disclosure to Google or Scientific American or the New York Times, but it is available to find, and you just have to know how to look it up. So these are things you have to check your provisional patent on before you file, or else you don't get your patent necessarily. It depends. There are lots of depends, but we're going to try to cover as many main points in these lecture series as possible. Okay, 102B2B. Third-party disclosure and not yet published patent which came from inventor. So I may have filed a patent previously, and I told someone about it and it isn't yet published. If it's been more than a year, then I won't be able to file a new patent on the same topic. If it's been less than a year, I could potentially file a new patent on this topic if it's significantly different and novel. If it's the same, then of course you cannot, because then it's the same subject as we covered already. 102B2C, filed but not yet published, disclosed by inventor and his team. So here is the case where I file a provisional, and then 6 months later I come up with a new idea, but it's similar to the old idea. Can I file the new provisional? It depends. If it's too similar to the old idea, then I cannot. But if it's significantly different, then I can. Okay, so that concludes my mini seminar for today. I hope you liked my brief review, and if you do, please click the subscribe button, and I will continue to add new videos on important content as we go along. Thank you very much.